Welcome to MidPoint. I'm Seán, I'm the host of MidPoint Monday. Today we'll look at a topic that comes up quite a lot in our discussions on this show. Are corporations citizens? And we'll also look at the influence of corporate money in politics. We're going to take your calls, so here's how you can join the conversation if you're interested in this topic. The number is 813-239-9663. You can also email your question or comment to dj@wmnf.org. You can text us at 813-433-0885, and if you call now, you'll be first on the air. Also, I should say that I don't think When the Levee Breaks has any plagiarism claims against it. Our guest in the studio today is Ciara Torres-Spelliscy. Ciara is an associate professor at Stetson University College of Law in Gulfport. Her new book is called Corporate Citizen, an argument for the separation of corporation and state. Welcome to WMNF's MidPoint, Ciara.
Thanks for having me.
Well, thanks so much for joining us. Why don't we begin our conversation where your book begins, Waiting for the Supreme Court's Citizens United decision. That was January 21st, 2010. What was that day like for legal scholars who were monitoring corporate power, and what was this case all about, and why do you consider it a turning point?
Sure. So this may sound like a fake story, but it really happened. I was waiting for Lyle, which is what constitutional scholars do when they are waiting for a Supreme Court decision, and the decision was finally released.
Who's Lyle?
Lyle is a reporter at SCOTUS blog, at least until about a month ago, and he reports on what the Supreme Court is doing. And because the Supreme Court doesn't allow cameras into the courtroom, often Lyle is one of the first people in the world to know if the Supreme Court has ruled in a particular way. And so when SCOTUS blog, his outfit, finally linked to the Supreme Court opinion in Citizens United versus FEC, I rushed to print it out, and then I sat there and read it for a couple of hours, because the whole opinion, along with the concurrences and dissent, is over 100 pages. And while I was reading this opinion, my hair literally started to go gray.
You're not being, you're not exaggerating.
I'm not exaggerating at all. I had a full head of brown hair when I started that opinion, and it started to go gray as I read it. And the reason I think that I had this visceral reaction to Citizens United is it was so horrible. It gave corporations the ability to spend an unlimited amount of money on politics, and that was a huge change in law. It changed federal law that had been that went back over 60 years. It changed certain state laws going back over 100 years.
So this is, you consider it a turning point, but if you look at the history of corporations in America, there's almost been a trend in this direction, but of course this is still a big turning point. Why don't we go back to the beginning and talk about what are corporations, or what are they supposed to be under American law, and maybe how that's changed a bit over the centuries?
Sure. So a corporation is a type of business entity, and it has a certain structure. The typical structure of a corporation, and it can vary slightly state to state to state, because corporations are creatures of state law. But the general structure is that you have a board of directors. They are elected by investors, by the shareholders. The board of directors then hires the officers of the corporation, and those officers run the corporation day to day. Now, over time, that corporate structure has changed. When we first started in the United States, corporations had to be created by an act of a legislature. So you had to go to a state legislature and get a special bill to create a corporation, which consequently meant that there weren't that many corporations at the beginning of America. Over time, that changed. So now, if you want to start a corporation, you simply file a few sheets of paper with the Secretary of State, typically, and you pay a few fees, and then you are the proud owner of a newly minted corporation. And over time, the Supreme Court has come to various forks in the road, if you will. where they could have limited corporate power or given corporations more rights. And the general trend over 200 years has been the Supreme Court giving corporations more and more rights. So if you look back at the very early Supreme Court, one of the first things that they are asked to do is consider whether the contracts clause of the U.S. Constitution applies to corporations or not. And they are also asked about corporate property rights. And in very early cases in the 1800s, the Supreme Court says, yes, we recognize very robust contract rights for corporations and property rights for corporations. And then over the years, the Supreme Court has come to different forks in the road. For example, after the Civil War, one of the big questions was whether corporations would be covered by the 14th Amendment's Equal Protection Clause. Was it a person for the purposes of the Equal Protection Clause? And the Supreme Court said yes, corporations are people for the purposes of equal protection.
And let's be clear here, we're talking about the 14th Amendment, the main purpose of which was to grant, guarantee the freedom for slaves. And then now it's being, let me use this word, usurped by corporations to get themselves rights. Now I'm using the personification language as well, but now corporations are getting rights from this really remarkable amendment. It's kind of, I don't know, it sounds kind of like a stretch to say that the 14th Amendment applies to corporations.
It was a huge turning point that the Supreme Court recognized corporate personhood after the Civil War. Many of the justices had served in the Civil War or had lived through the Civil War at the very least. And they knew that the 14th Amendment was meant to empower newly emancipated slaves. But newly emancipated slaves were not the first people litigating their cases up to the Supreme Court in the years that followed. Instead, it was corporate lawyers who thought, aha, if we can convince the Supreme Court of this could open up a whole new way of fighting regulation. And indeed, that is what happened. Corporate lawyers used these personhood arguments, these equal protection arguments, to argue against regulations that would have otherwise applied to corporations.
So let's look at the flip side of this, and I should say again, my guest is Ciara Torres-Spelliscy. She's a professor at Stetson University College of Law. Her book is called Corporate Citizen, an Argument for the Separation of Corporation and State. You're talking about how courts have granted more and more rights to corporations. What about responsibilities? Have courts tended to add more and more responsibilities while they're giving corporations more and more rights?
No, and this is what I find sort of troubling. So in my job as a law professor, I teach both constitutional law and corporate law. And what I saw in my constitutional law cases is that corporations are getting all of these new rights, including First Amendment rights, political speech rights, religious speech rights. Meanwhile, when I teach corporate law, I saw that in many cases, courts are excusing corporations from certain responsibilities that you might think of as linked to the rights that the Supreme Court is giving. So when you're talking about a normal human being, the court usually conceptualizes rights and responsibilities as attaching at the same time, but not so when we're talking about corporations. So the area that I find sort of the most troubling is in the area of human rights law. So there have been a series of cases where the Supreme Court has basically excused corporations from having to be defendants in human rights abuse cases, basically because those human rights abuses didn't happen on U.S. soil. But it also seems to turn on the fact that these are corporations, and the court is yet to recognize a very robust set of responsibilities for corporate actors in that space.
So it wasn't Citizens United that gave corporate personhood, as we've maybe been hearing the last 5 years. This is a history that's gone back for centuries. Can you talk specifically about one that happened, a case in the Supreme Court that happened in 1886, Santa Clara County? How did that, what is the role of, how did corporations gain more rights in that case?
Sure. So, with Santa Clara County, it's such a bizarre little piece of legal history. There were arguments that were brought up in an earlier case, about 4 years earlier, by a lawyer named Roscoe Conkling. And Roscoe Conkling had been a U.S. senator, and he was on the original drafting committee of the 14th Amendment. After he was a U.S. senator, he became a corporate lawyer, and he became a lawyer specifically of many very wealthy railroads, when railroads were one of the biggest industries in America. And he made an argument in a previous case that the Supreme Court didn't actually seem to rule on, but basically his argument was that the drafting committee of the 14th Amendment had to choose the language that they were going to put into the Equal Protection Clause. And the Equal Protection Clause today includes the word people or persons. But the drafting committee, he argued, was choosing between persons and citizens, and it chose persons so that corporations could be covered by the clause. Now, historians have gone back and looked at this, and they really think that Roscoe Conkling was just lying to the Supreme Court, that this was ridiculous, that this was an argument that he made in the course of litigating a case and had nothing to do with the actual drafting of the 14th Amendment. But in Santa Clara, the Supreme Court, before they issue the opinion, the Chief Justice just starts talking. And one of the things he starts talking about is how the court really doesn't want to hear arguments about corporate personhood. And I'm paraphrasing here. He says something to the effect of, we already recognize that corporations are persons. And then that becomes what's known as a headnote to the case. Now, the headnote is just something that an editor puts on top of a Supreme Court case. It is not actually part of the holding itself. But future Supreme Courts, for reasons that seem really strange, cite to the headnote as if it were part of the actual case. And so you get many, many more cases in the future where the court cites to Santa Clara for the proposition that corporations are persons.
So typically in a court case, you would have a 5-4 vote or a 7-2 vote, but this headnote of Santa Clara wasn't voted on at all. It was just one person, a very powerful person, just talking, and essentially set, I don't know if this is the right word, but set precedents for generations about corporate personhood, just kind of going off the cuff and giving a speech, and it was treated as if it were a voted on decision by the Supreme Court.
Indeed. And so after Santa Clara, the Supreme Court, to this day, has taken the position that a corporation is a juridical person.
Well, let's fast forward about 90 years to the 1970s in the Belotti decision, which said that corporations can spend unlimited amounts on a ballot initiative. Well, how does that still play a role in today's thinking about corporate money?
So this also has a great backstory. So there is this case called Belotti, and it was a challenge to a Massachusetts law which limited corporate spending on ballot initiatives. And at the time, Justice Powell wrote the opinion, and it was another one of these 5-4 opinions. Justice Powell, before he was Justice Powell, was a very powerful corporate lawyer. And before he was on the court, he wrote what is now known as the Powell Memo. Now, the Powell memo was a memo to the Chamber of Commerce, and it argued that businessmen were the forgotten man in American politics, and that corporations and businessmen needed to work hard to cultivate political power. And this memo did not come up during Justice Powell's confirmation hearings in the Senate. Instead, what the Senate seemed to be concerned about was his vast stock holdings. And so what they really focused on is, are you going to sell your stock holdings before you put on judicial robes? And to his credit, he sold his vast stock holdings before he ascended to the Supreme Court. But looking backwards, when you look at the Powell memo and the Belotti decision, it really looks like Justice Powell wrote his view of corporations into constitutional law. And the really clever thing that Justice Powell did is he said the First Amendment protects the speech and not the speaker. So it does not matter that the speaker here would be a corporation. The Supreme Court agreed with him, and that has been the law since the 1970s.
Our guest is Ciara Torres-Spelliscy. She's an associate professor at Stetson University College of Law in Gulfport. Her new book is called Corporate Citizen, an argument for the and that's with a question mark, corporate citizen, question mark, an argument for the separation of corporation and state. The number to call in is 813-239-9663. You can email your question or comment to dj@wmnf.org. You can text us at 813-433-0885. It's 12:23 in the afternoon on WMNF Tampa. You're listening to MidPoint. My name is Seán Kinane. And Ciara, I want to, earlier when we were talking about Santa Clara, the decision there, or the head note there, you differentiated between two words that might sound similar to a layperson but have a very different legal meaning, and that's corporate personhood versus corporate citizenship. And this is a word that's in your title of your book as well. So can you differentiate between corporate personhood and corporate citizenship?
Sure, and these are very contested terms, so I'm sure if we got a couple of lawyers in a room, they could all disagree over what corporate personhood means and what corporate citizenship means. So personhood from a legal standpoint usually means the capacity to do something. So corporate personhood in contract law means that you can make a contract, you a human being, with a corporation, and that will be a binding legal contract. Similarly with property law, corporations as legal persons can own property. Corporate citizenship has, I think, multiple possible meanings, and I put a question mark at the end of that in my title, in part to be provocative and in part to indicate all of the dispute over this concept. So one version of corporate citizenship is just where that corporation is incorporated. So if you are incorporated in the state of Florida, then the citizenship of that corporation is Floridian. Another way you can think of corporate citizenship is the amalgamation of rights that they have been getting throughout time, including most recently political rights from Citizens United and religious rights under the Hobby Lobby decision.
Yeah, I think a lot of our listeners will be confused about that. How can a corporation have a religion?
That is such a good question, and I'm not a Supreme Court justice, so I can't get into Justice Alito's head. He's the one who authored the Hobby Lobby decision. But the 5-4 decision in Hobby Lobby grants at least closely held corporations, which are smaller corporations, the ability to make religious objections to generally applicable laws. In the Hobby Lobby decision, it was a challenge to the ACA, the Affordable Care Act, sometimes known as Obamacare. And a closely held corporation, Hobby Lobby, objected to covering certain types of contraception under the ACA's coverage formula for their female employees. And the Supreme Court said that Hobby Lobby could make a religious objection. Now, in the Hobby Lobby case, they didn't decide it on First Amendment grounds. They didn't have to. They used a statute called RFRA, the Religious Freedom Restoration Act, to give these religious rights to Hobby Lobby and to similarly situated, closely held corporations. But it is peculiar because I think before this decision, the Supreme Court had never given a for-profit business corporation the ability to make a religious objection. So this is new territory for all of us.
This court, the current court, Chief Roberts, John Roberts is the, it's called the Roberts Court. He's the Supreme Court, I can't think of the name, the Chief Justice.
Yes.
And you mentioned the other four conservatives that were on the court. Of course, recently Justice Scalia has died, and so now, how do you think that Scalia dying, and perhaps maybe there will be a replacement for him in the near future? Perhaps maybe not. We don't know. How do you think that will change how friendly this court is being toward corporations?
Well, it all depends on who takes the Scalia seat. If you get someone who is more progressive on money and politics issues, or is more sensible on corporate law issues, then you could have a lot of decisions which were decided by the Roberts Supreme Court up until this point reversed, because then you would have 5-4 the other way. On the other hand, if you get someone who believes the same things that Justice Scalia believed, either about corporate power or about campaign finance, then it's possible that what we saw in the first decade of the Roberts Supreme Court will continue many decades to come.
And it might even be where we see the division in the politics in the Senate, and if there's a different party in charge of the Senate versus the presidency come November, this might stretch out longer than just an election year. It might be years before we have a new justice.
Yeah, I told my constitutional law class that, and they sort of looked at me as if I were making things up, as they often do. But the vacancy on the Supreme Court could go on for a very long time if you have a different party controlling the Senate than you have controlling the White House, as you said.
We're getting slightly off topic of your book right now, but I mean, this is a really interesting topic, and I think that people will be interested to know about it. We've talked about it on this show before, but is there a precedent for that? What's the longest we've gone with 8 justices?
I feel like we've crossed a new threshold where this is, I think, the longest vacancy that we've had in recent history, and your listeners should know, the night that Justice Scalia died, the majority leader in the Senate, Mitch McConnell, said that he would not hold hearings for the replacement until the new election happens in November. And at that point, I think it was January, so he was basically threatening to hold this up for at least 11 months.
The process, and then after that, now you go through hearings, and that takes probably weeks or months. And I'll repeat it, but it doesn't seem like if we have a similar dynamic and come January, it doesn't seem like much will change.
Yeah, this vacancy could be there for a while, and we have aging justices, so they're all aging at the same rate. But I think there's some stat about the average age of the justices is something in the high 70s, I think. And so we're going to have other retirements in the new presidency. The question is, will we actually fill these vacancies? I mean, there is the recess appointment power, which may come into play. It's one of these safeguards that our clever founding fathers built into the U.S. Constitution, that if you can't get the Senate to confirm a nominee, the president does have the ability to have a recess appointment.
And then you have equally clever senators who don't recess when it's time to recess.
Indeed.
813-239-9663. If you'd like to join this conversation, we're going to go to the phones in just a second, and you can also email us at dj@wmnf.org. You can text us at 813-433-0885. My guest is Ciara Torres-Spelliscy. She's an associate professor of law at Stetson University College of Law in Gulfport. Her new book is called Corporate Citizen, an argument for the separation of corporation and state. We'll go now to the phones. We have John in Newport Richey. John, what's on your mind?
Oh, Justice Kennedy is usually considered a conservative. Breyer is usually thought of as a liberal justice. So the way our Supreme Court works is they can't just decide things without a case in front of them. And so what they will have to do if they want to reverse any of this case law is they have to wait for a case to bubble up from the states or from DC or in a challenge to a federal law. And once that real case or controversy is litigated up to the Supreme Court, that gives the court the opportunity to revisit some of these precedents. Now, there is a strong norm in favor of holding to precedent, as in if the Supreme Court has ruled a certain way, they are likely to rule that way again. But on the other hand, we've had reversals of precedent, even with the Roberts Supreme Court. So